So here's some things I would never do as an estate planning attorney and what I would do instead. So as an estate planning attorney, I get a unique perspective on what works and what doesn't work when it comes to planning for the future. So we're going to walk through a couple of things today that I would never do as an estate planning attorney, especially when planning for your children and your loved ones. So I'll share also what I would do instead. So number one, naming minor children as direct beneficiaries. One thing I would never do is name a minor child as a direct beneficiary on a financial account or life insurance policy. Minor children can't legally inherit assets directly without the proper planning. This can lead to expensive, complicated court proceedings. You always want to set up a trust instead. So that's what I would do. I'd set up a trust for any minor children. You can name the trust as the beneficiary of those accounts or life insurance that passes by designation, and you can designate a trustee, so an adult, to manage those assets for that child until they attain a certain age. Second thing, I would never name a single child as the executor or trustee without a backup. You always want to have a backup. Now, this may seem straightforward, and you may think nothing will happen to that named executor or trustee or power of attorney, but life can change very quickly. We always want to have a backup. So what I would do instead, always name a backup executor or trustee or agent under the power of attorney, or maybe a co-executor or co-trustee, so that we always have that backup in place. The third thing, transferring assets directly to family members without considering a trust. I'd never transfer significant asset directly to family members, such as a house, without considering the benefits of a trust. Adding children, for example, to the deed of your house could, number one, expose your property to the child's creditors or a divorce proceeding, and also it has some negative tax implications because that child will receive a carryover basis. So then if the child in the future sells that property, they're going to be hit with a capital gains tax if it's not their primary residence. So what I do instead, use a revocable trust, or you can even use an irrevocable trust if you're trying to protect assets, and you can still have it so that the child can receive a step up in basis. It protects the assets from creditors, bankruptcy, divorcing spouse, and the child can also receive a step up in basis after you pass. The fourth and final thing, forgetting to regularly update beneficiaries and your estate planning documents. Situations change over time, so it's essential to keep up with everything as it's progressing. So what I do is instead, set a reminder for yourself every 3 to 5 years, or after any major life event like a new child, a marriage, a death in the family, to ensure that your plan accurately reflects what your current wishes are and what your family needs are. Estate planning is one of the best ways to protect yourself and the people you care about, but it's easy to overlook a few details on the way. I hope this video helped. If you need any help from us, please reach out.